you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 21st, 2025,
The officer linked it to organized criminal activity, meaning this wasn't just a case of someone stealing a trailer. It was done as part of a crew. Prosecutors are arguing this wasn't a random act, but a planned operation.
dispatched to a residence in Harris County, Texas. In the call notes from dispatch state, the reportee says an unknown party stole her neighbor's U-Haul trailer. Subjects were seen headed towards Pasadena Boulevard. The driver was a skinny, tall male, and the reportee lives on Buchanan Street and has camera footage of it happening. A witness stated he observed individuals taking the neighbor's U-Haul. The officers located the U-Haul and a felony stop was conducted. Defendant Hentoja was observed unloading items from the U-Haul, ran to the back of the residence, and prevented officers from arresting him. Defendants Lopez and Cerda remained in the U-Haul, and the complainant stated the value of the trailer was $1,800 and dirt on the trailer was $300.
I have so many questions.
Yes, Judge.
I don't even know where to start.
Judge, my concern is, if you may, I want to just bring some, I guess, some points of argument to the court's attention. The first one, my concern is that, the 911 caller mentioned unknown parties, and then the police officer later mentions them as suspects without any type of articulable facts, believe that they are the specific people or the individuals that have taken this U-Haul. Now, as we know, probable cause requires more than a hunch, more than suspicion. It requires something else, more than that. And that seems that that's all that the things, at least under the four corners of the things, allege that my client was involved with this alleged theft.
Remember, so when they start.
This is a classic legal move. The defense argues that being near a crime doesn't make you a criminal, and they're right. In Texas, just sitting in the car doesn't mean you're involved.
An investigation, sometimes they just don't have everything, and facts develop in time.
Right.
Here, we have a call that several people have stolen a U-Haul,
Yes, Judge.
and they've given a description of a tall, lanky person,
Yeah.
right?
Yes, Judge. And respectfully, we defer to the court because all it says in the DIMS is that the defendant Cerda remained in the U-Haul. There's no further information regarding Cerda.
Where was he in the U-Haul? Was he in the actual U-Haul? Was he in the truck that was driving the U-Haul? How was he engaged in this alleged criminality?
And Your Honor,
Can you just, does mere presence impute criminality?
No, Judge, and that's exactly right. Texas law says that mere presence is not enough.
Dude,
to bring trouble.
I'm with you.
Oh, yes, sir.
But, so,
we're not arguing against that, Your Honor. And like I said, we defer to the court because we don't have that information. We'd have to await the OR, and we don't have that at this time.
but I'm not going to sit here and
Yes,
hold
Judge.
someone.
And that's why we defer to the court.
Let's look at what the statute says, because, a person commits an offense if with intent to establish, maintain, or participate in any combination or in the profits of a combination or as a member of a criminal street gang, the person commits or conspires to commit one or more of the following. One is murder, capital murder, arson, yada, yada, yada. Two, any gambling offense punishable by a Class A misdemeanor. Promotion of prostitution. Number four, unlawful manufacture, transportation, firearms. Which one are you relying on?
Your Honor, as it's pled, is that it's pled as theft as being the underlying basis of the engaging in criminal activity. And right now, Kelsey is looking at the case. We may very well dismiss this because of the insufficient evidence in the information in the DIMS. But right now, Chief is looking at it.
And Your Honor, if we could just maybe reset it for a week or so, we call the witness. And we have to decide.
He's in custody, and I can't, if he was on bond, that would be one thing, but he's in custody. I'm not going to hold him just because, and the compounding it, Casey, is that he's got an ICE hold, so I can't give him a PR bond,
I just need a little more time, Your Honor, to dismiss it right now.
Yeah, I'll find no PC because I just don't think it's there for now. And then if you find something later on, by all means, but all right, Mr. Sir, I'm going to find that there's no probable cause to go forward in your case.
Case tossed, no probable cause. But did you catch that warning? The judge essentially says, next time, things won't go so easy. making it clear that leniency has limits and future actions could have serious consequences.
Just, Mr. Serta, be careful who you hang out with, you know? Okay, all right, for sure.
Counsel.